All right, let's talk about single agent relationship. So this comes out of chapter 4, unit 4, which is authorized relationships, duties, and disclosures. 7 questions. This is a pretty big section that you want to be familiar with. Okay. Now, let's just talk about a little bit about single agent. Remember, in Florida, you are automatically a transaction broker. Okay. There is no requirement to disclose that. It's an automatic, if you want to call it an automatic relation with your, at that time, is going to be a customer. So you're automatically a transaction broker. In order to become a single agent broker or a single agent relation, you've got to disclose in writing. Okay. You have to disclose in writing a single agent form. You'll have access to all these forms when you get to your brokerage firm. You're going to join NAR and you're going to be a member of the Florida Association of Realtors. They got all these forms in your brokerage unit. Okay. So automatically you're a transaction broker, which means they're a customer. You're in a non-fiduciary role. In order to become a fiduciary or in order to become a single agent relation, you have to give them the form single agent relation. It's a single agent relation form that explains all your duties, okay, as a single agent. Again, those are all pre-printed. It's not required to be signed. You just got to disclose. And then you now, and if it's an acceptance, you become a single agent relation with your now not customer, but client. Okay, so from transaction broker, they're a customer, non-fiduciary, you're just a transaction broker. You give them the single agent form. Now you become a single agent to them with a fiduciary role. Okay. So the time to make this disclosure is before, at the time of entering a listing agreement or buyer agreement, before showing the property. Remember, principal and client are going to be now who they are to you as a single agent. As a transaction broker and a no brokerage, they're customers. Okay. Now, what does single agency mean? It's a fiduciary representation that you have to a buyer or seller. You're working for one person. Now, I'm going to ask you a true false question here. Okay. I'm going to ask you a true false question. Is dual agent, listen to me carefully now, listen to my question. Is dual agency allowed in the state of Florida? True or false? Is dual agency allowed? Okay. Is dual agency allowed? Okay, I got all false answer, but I got one true answer, which means someone is saying dual agency is allowed. If dual agency is allowed, under what conditions can you be a dual agent? Is there ever a time you can be a dual agent? Is there ever a time you can be a dual agent in Florida? What would that be under? From your studies, when can you be a dual agent? Right? When can you be a dual agent? Remember, under the law of designated agency, when you're dealing with commercial property, remember the client has to have $1 million in assets. They have to request dual agency. You can be a dual agent under a designated agency, which is in commercial, and that's requested. Okay, so go review that. What you want to pay attention to in the question is dual agency is not allowed in Florida under residential sales. Okay. When you're dealing with residential sales, dual agency is not allowed. You're absolutely correct. But in all cases, if it's a general statement that says, is dual agency allowed in Florida? And it says, well, it depends. Are you selling a home, condo, land, residential, or are you selling commercial property? Because under the law, commercial property, you can act as a designated agent and actually be a dual agent to a buyer and seller, okay, upon their request. Remember, they got to have $1 million in assets, the clients do. So go review that, okay? Very important that you understand that, because if the test question doesn't really designate it, you got to be careful, because that's how Pearson VUE can hook you and trick you on that. Okay, so let's go back to residential. You are absolutely right when you say no dual agency under residential. You're absolutely right. Okay, so what does single agency mean? It's the fiduciary representation to either the buyer or seller. Now, this term special agent is a term that you're going to see under agency relation that deals specifically, okay, specifically the duties of a single agent. Okay, it's called a special agent. In other words, a listing agreement. I'm going to execute and buy and sell a home for you. A buyer's agreement. I've got a single responsibility to find you a home. Okay, it's not what's known as universal agent or a general agent, but we're calling it a special agent. Okay, a special agent has to deal with a specific duty that you're doing as a single agent for a seller or a buyer. Okay, so the question may read, a real estate broker, when working in a single agent relationship, there's my key word right there, is typically authorized by a principal to act as what? Okay. Excellent. That's right. We're talking about a special agent, right? That's what special agent is defined. You're executing a single fiduciary responsibility to your client. Okay. So we're talking about answer D. Very good. That's awesome. Good job. What you have here in this slide is what does 475 define as residential property? Remember, we said that you can only perform single agency in residential properties and not dual agency. Okay. Dual agency is allowed under the designated agency law with commercial property, but not in residential. Well, what do we define as residential? Well, here's 475's definition of residential sales. Residential improvement. Improvement means house or building. Okay. Could be a fourplex, a condo, whatever. Residential improvements up to 4 units. Okay. Single family, duplex, triplex, fourplex. Land zoned for up to 4 units of new construction. So raw land, but it's got to be zoned residential for up to 4 units. And then property zoned for agriculture of 10 acres or less. That comes under the definition of residential sales. Okay. And that's going to apply with you and whoever you're dealing with as a transaction broker, a single agent broker, or a no brokerage. Okay. Those 3 entities apply to residential sales along with no dual agency in any of these properties that are defined by Florida Statute 475 as residential sales. Okay. Now, we do have some exemptions when it comes to that, right? We do have exemptions when it comes to disclosure requirements. In other words, your transaction, your single agent, your no brokerage. So here are the exemptions, right? Non-residential transactions, we talked about that. Commercial, there is no agency disclosure requirements for that. If you're doing a lease, okay, unless it's an option, which is a purchase agreement with an exercise date, rents or lease are exempt from agency disclosure requirements. Business opportunities, unless it's 4 or less residential units. If it's a business and it has to do with leasing property up to 4 units, then it's exempt if it's not included in that. Auctions, appraisals. So you want to know a few of these. The big ones you want to know is non-residential or commercial transactions, rent or lease. Those are exempt from agency disclosure. Otherwise, when you're dealing with residential sales, you have to know by definition what they define that as. Okay. Improvements up to 4 units. Land zoned for up to 4 units for improved construction. Improvement construction. And then property zoned for 10 acres or less. Okay. All right. So the question reads, the brokerage relationship disclosure requirement in Chapter 475 Florida statutes do not apply to what? Good. Excellent. Good answer. So we know answer A, answer C, and answer D fall under the definition of residential disclosure. Okay, that's residential sales. Okay, leasing is an exemption, as we saw in our studies. Okay, so we're talking about answer B. Answer B. Good job. Excellent. All right, let's talk about, again, we're going to circle back to chapter 4. This is the relationship, duty, and disclosures. We talked about single agency. We talked about transaction and no brokers. Let's do a little bit of a review again. Remember, transaction brokers, you are automatically a transaction broker when you engage in real estate activity with a customer. That's what they're going to be called, a customer. There is no disclosure required. And you want to get with your brokerage, your broker, and find out what company policy they may have in place and how you are going to approach when you start doing real estate activity when it comes to these three different types of agency relations. Okay, so transaction broker is automatic. In order to go to a single agent or a no brokerage, you have to just provide a disclosure in writing, and it's going to be a disclosure form, single agent broker or a no brokerage. Okay, that has to be provided to your client or your customer. Now, under transaction broker, it provides limited representation. Okay, that word limited representation under a transaction broker means you have to uphold somewhat of a confidentiality with them. Now, here's the question I'm going to ask you. Don't be tricked by this now. Can you work with a buyer and a seller as a transaction broker? Can you work with a buyer and seller as a transaction broker? Okay. So if you say, yes, I can work with a buyer or seller as a transaction broker, I thought we talked about earlier, we couldn't do dual agency in residential sales. Okay. So the only time when dual agency is not allowed is if you're holding the position of a single agent broker relation. Okay. In other words, let's say you're working with me, I'm listing my home, and you come over to my property to look at it, and you're looking at my property, and we sit down at the table and we start discussing the listing agreement, etc. Your engagement with me, touring the property, and just called ministerial acts, it's just information. Okay, it's an interview. You're a transaction broker at that point. You came into my home to look at the home and to discuss the possibility of listing. We haven't engaged in any type of agency relation agreement yet. And so the law says you're automatically a transaction broker. That's where you're sitting with me. We're touring the home, talking about listing, et cetera, et cetera. So we sit down at the table, and I like the program you want that you're bringing and what kind of marketing you're going to do. So I'm going to go ahead and list my property with you. At that point, you would, if you wanted to put a fiduciary responsibility onto me, you would disclose to me in writing, which is the form. I don't need to sign it, but you would disclose to me, and I would accept, yes, I want you to be my single agent. I want you to have a single agent brokerage requirements to me, which means you cannot now be a dual agent with anyone in your firm or any other buyer that you may have. You can't do that. Okay. So now I'm a client to you. So you went from transaction broker to disclosing a form with me, and now you're in a fiduciary role to me, and I'm called a client now. I went from a customer to a client. Okay. Now, if you wanted to go from transaction broker to no brokerage, you would have to disclose that in writing. Again, I'm going from customer and I'm still maintaining a customer relation. Okay. So automatically a transaction broker. To actually go to a single agent or go to a no brokerage, you must disclose in writing. Okay. Those are the forms you got to give out. Okay. No dual agency is allowed as long as you're a single agent. Okay. Or a single agent relationship. All right. All right. So the question says, the broker and the seller agree to a single agent representation. So use the example I gave you. The broker must, and what is your answer? Okay, got a couple of mixed answers. Let's go back and review. Let's go back and review real quick. Remember, automatically, use the example I'm giving you here. You show up at my listing. I invited you to come because I want to interview you for a listing. We're walking around the property. I'm pointing all the good things out, et cetera, et cetera. It's just ministerial, only information. We sit down at the dining room table. You pull out your marketing plan, and we're talking in detail about that. And then I commit to you and I want you to be my single agent. And so I want to be a client to you. I want you to have a fiduciary and work with me only, no other buyers. So you're going to give me in writing, which is the form. You're just going to disclose and say, look, here's my duties. This is a disclosure statement that's required by law. That's it. Doesn't have to be signed. Just got to disclose it to them. Okay. So the broker and the seller agree to a single agent. The only thing the broker's got to do is give the seller a single agent notice. Okay. Answer A. That's all the broker has to do. Okay. So we're talking about answer A. Give a single agent notice. Very good.
For more practice questions, videos, and insight into the state exam, we encourage you to join our free webinar, How to Pass the Real Estate Exam Without Your Real Estate Book and with only 15 to 20 hours of study time. Get registered now at myrealestatetutor.com/exam.